Good evening, everyone. The hour of 6 p.m. having arrived, I will call to order this regular meeting of the Planning, Licenses, and Development Committee. The meeting is being broadcast live on the City of Keene YouTube channel and channel 1302. The video is also streamed on the city's website and posted on the website by the end of the next business day, barring any technical difficulties. Copies of the printed agenda are available in the wall pocket as you enter the meeting room. The public and other city councilors will be recognized to ask questions and comment on the agenda items under discussion. After being recognized, all remarks are to be made through the chair. I will not recognize an individual a second time until everyone who wishes has had a chance to speak. Anyone who wishes to address the committee is asked to go to one of the microphones in the room and identify themselves by name and address prior to speaking. Written comments from the public will be accepted at the city clerk's office until Tuesday at 1 p.m. I will now call to order this regular meeting of the Planning, Licenses, and Development Committee and declare a quorum present. The minute taker is participating remotely this evening, so council members, please remember to turn your microphones on. We have a little bit of a few items, a lengthy agenda tonight, and I want to get right to it. Our first item is the Keene Snow Riders requesting permission to run snowmobiles in the right-of-way along Criff Road from Ashwillet Rail Trail to Winchester Street. And I believe we have George Thompson here tonight. Ah, yes, great, come on forward.
Evening, how are you?
Good evening. Can you tell us a little bit about your request this evening?
Yeah, it's a renewal. Each year, the Snow Riders Club requests permission to cross as that connects the rail trail from Swansea to the rail trail in Keene.
Okay. And have you met with city staff about the request this
Yeah,
year?
Jeremy Evans is the president. I'm here on his behalf tonight. He's traveling, but everything should be in order regarding the application, yes.
Great, thank you.
Yep.
And do we have comments from staff? Rebecca? No?
We have no additional comments at this time.
So I do know that this is an annual request, and what I can say is that it has, like, we don't ever have any negative feedback. I feel like you guys do a pretty good job of following the criteria that we set forward, and we really appreciate that.
Sure.
And we're glad to see you coming back again. Do we have any comments from the committee? Councilor Jones?
Just, George, a special thank you, because I know what you do to groom the trails and everything for us. That's a big help to the city.
Oh, you're welcome.
So thank you very much for all you do.
No problem, thank you.
Great. Anyone else? Okay, I guess I would be open for a motion.
Move to recommend the Keene Snow Riders be granted permission to use the following locations on city property for a snowmobile trail. The right-of-way along the north side of Criff Road from Criff Court to Winchester Street, city property identified by tax map numbers 116/040/000/000/000, 214/003/000/000, and 118/001/000/000/000. The crossing of Winchester Street at Criff Road and the crossing of Production Avenue, approximately 200 feet plus or minus, 200 plus or minus feet south of New Hampshire Route 9, as well as the access to the Class 6 portion of the old Gilsum Road, starting at approximately 1 mile from the Gilsum town line and going north premises for the following purpose: for a snowmobile trail and under the following conditions. Said use shall commence on December 15th, 2024 and expire on March 30th, 2025, and is subject to the following conditions: the signing of a revocable license and indemnification agreement, and the submittal of a certificate of liability insurance in the amount of $1 million, naming the city of Keene as additionally insured. In addition, the Keene Snow Riders, Inc. will be responsible, including all associated costs, for furnishing, installing, and maintaining of all signage/marking, which shall be furnished and installed in accordance with the snowmobile trail standards published by the New Hampshire Department of Business and Economic Affairs and the Manual for Uniform Traffic Control Devices, MUTCD. All signage markings shall be removed from the city right-of-way and city property when there's no longer any snow cover. No structures, including but not limited to buildings, shelters, lights, displays, walls, etc., shall be permitted within the city right-of-way or on city property. No parking of motor vehicles or trailers and no catering servicing activities of any kind shall be permitted within the city rights-of-way or on city property. Grooming shall not extend outside the right-of-way on Criff Road. Snow windows shall be groomed to provide adequate sight distances in conformance with AASHTO standards and a gentle sloping approach at all road and driveway intersections. No part of the city street paved surfaces may be used by off-highway recreational vehicles, OHRV, or their operators for any purpose other than direct crossing, and that Keene Snow Riders, Inc. shall be responsible for the repair and damage, including costs, and the city right-of-way and property shall only be used when there is snow cover. All crossing of public right-of-ways shall be made and maintained as perpendicular with the right-of-way being crossed.
Second.
We have a motion and a second by Counselor Jones. Does anyone have any questions on that motion? City Manager?
Just a point of clarification, sorry for the confusion earlier. The snow riders don't typically go to a protocol. Those are typically just held for events. However, this request was reviewed by the Public Works Department, and the city's engineer did give us his comments related to the motion, and so we're prepared to move forward this evening.
Great, perfect. Thank you so much.
Thank you.
Do you have any questions on that motion? I know it was rather lengthy.
No, it's all encompassing.
Okay, great. Oh, sorry, Counselor Haas.
Thank you, Chair. How many years have you been doing this request and been getting this approval?
Well, the Snow Riders were incorporated, I believe, in 1985. I don't know the length of time that this requirement was put in place to cross city right-of-ways, but since I've been on the board for 3 years, we've done this every year, and I know it was in place before that, too.
Yes, and likewise, every year that I've
Yeah,
been here.
So many years. So
Many years.
congrats- And I've never heard any bad word or any negative comments, so thank you. Keep it up.
All right. Without seeing any additional comments, all in favor? And that is unanimous. That'll go to full council next week.
Great, thank you very much,
Thank
appreciate
you.
it.
Thanks, George.
Item 2 is the Greater Monadnock Collaborative's request to use city property for Central Square and Railroad Square for a 30th anniversary celebration of the release of the film Jumanji. And I have a note here that it looks like we have Kathy Bergstrom, but I don't see Kathy here tonight. Yes.
Thank
Rebecca.
you. Rebecca Landry, Deputy City Manager. We had a meeting, a protocol meeting involving Kathy Bergstrom and some members of their board, and they learned enough about what's coming next year with the downtown project to really come to the understanding that they didn't have enough details solved on their end to determine what the exact route, road closures, location of the celebration would be. So they asked us to put it on more time. They
Okay.
do intend to come back next month once they have nailed down exactly what the specifics will be for the event.
Okay. Does anyone have any questions about that? Anyone from the public? All right, seeing none, I would ask for a motion.
I would move to put this on more time.
Do I have a second?
Second.
A motion by Counselor Jones, seconded by Counselor Haas. Any questions again? Seeing none, I would ask for a vote. All in favor? And we'll put that on more time for them. Hopefully, we'll hear back from them next month. It's making our agenda a little faster, guys. So item 3 is the Charter Communications request to install a concrete pad and utility cabinet at 555 Roxbury Street. And I believe we have Tom Converse and Keith Cornier. I'm hoping I did that okay. Here to speak on behalf of Charter Communications. Want to come forward?
Good evening, how's everyone doing?
Good.
So I'm Tom Converse, that's Keith, and got Ryan here too. He did a great job last time for us, so we brought him along. Yeah, so we're trying to put a cabinet off to the side of the road there, right by where one of your current utility buildings are, to first off better serve having better uptime for your facilities. You know, the year before last, we had that large snowstorm with our facilities on the top of the mountain up there. We had a really hard time getting in and out of that area with all the snow. And this will make it for more reliable uptime, and then with our current upgrade that's gonna be beginning here shortly, it'll be easier access for us to get to there, to maintain it if need be.
Okay. Do we have any comments from staff on this?
Since this is not a use of the city right away, it's use of the property, it's coming through the licensing process, but before anything is authorized, we'll make sure that Public Works is comfortable with the location.
Okay. And do we have, we don't have any comments from Public Works
No,
at this point?
no.
Okay. And is that part of, going to be in the motion, that that will be conditional?
No, I don't think it needs to be conditional, because this all happens through the city manager, and the authorization is to negotiate and execute with charter. So
Okay.
whatever the requirements are for Public Works, we can just fold into it.
Fold in here, perfect. Okay. Counselor Williams?
I would just hope when Public Works does a review, there is one of these boxes already on, I think it's on Roxbury Street, although maybe I'm thinking of Beaver Street. But there's right in front of it, the sidewalk just makes a big dip. That was a result of when it was installed. And then that fills up with water, and then that turns to ice in the winter. So I would like to avoid that situation. So just make sure that, nothing is left behind that's going to collect water where people are going to walk.
Counselor Jones?
Thank you. I'm reading in the letter that it's going to be fed with underground conduit. Is any of that going through private property, or?
Nope,
Is
so
that
it'll
in a
go
public
right
park?
from the telephone pole that, right there is at the end of the road, and it'll go directly through there underground.
Oh, just that small portion, okay.
Yep, yeah,
Thank you.
yes, sir.
Counselor Haas?
Thank you, Madam Chair. This is at the water tank facility up
Not
on
quite, the
Roxbury?
one around the corner, actually, going up it's off of Chapman, correct, Ryan?
Yeah,
Yes.
it's where the current
I know, the address takes
antenna
me there.
site is.
So it's up at the antenna site. So
It's at the bottom of the road from there,
it'll be
yep.
at the bottom of that
Yep.
road, and there's no sidewalks there or anything.
No,
so-
sir.
Okay, and it's off the road.
Yes, sir.
Yeah, it is gated too.
Yep,
Okay.
great, thank you.
Anyone from the public wishing to speak on this? You have
I
your-
just have one question.
Okay, yes.
Mr. Williams, if you want to give us that address so we can check the where you're talking about, where it dips down, and we'll have Ryan go out there and check it tomorrow and make sure it's not ours. I know it's not related to this, but if it is ours, then we'll try to take care of that for you guys too, because,
Okay, thank you.
yeah.
So seeing no more comments, I would be open for a motion. Counselor Haas?
Move to recommend that the city manager be authorized to do all things necessary to negotiate and execute a standard form city license to Charter Communications for the installation by Charter Communications of a concrete pad and utility cabinet on city property located at 555 Roxbury Street.
Do I have a second?
Second, I'm sorry.
I have a motion by Counselor Haas, seconded by Counselor Jones. Any questions on that motion? Seeing none, I would ask for a vote. All in favor? And that is unanimous. That'll go to full council next week as well. Great. Thank you, guys.
Thanks, guys.
All right. Item number 4 is Counselor Remy's modification or rescission of Council Policy R 2000-28, Street and Utility Requirements and Standards. And I spoke with Counselor Remy today. He asked if I would speak on this on his behalf because he's traveling for work this evening. This is something that we have dealt with at this committee several times in the last several months. And we have discussed how this policy in and of itself is a little bit dated. And I think it's probably time to revisit it. And I appreciate Counselor Remy putting this letter in to force our hands and put it on the agenda tonight. I think that I've spoken with the city attorney and that there's some opinion that that's not a bad direction to start in, that there is a state RSA that covers these decisions, and that this is a little bit redundant to have. We have been reviewing each of these items on their own merits anyway, and so considering a rescission of this policy is not necessarily out of character or line for what we should do here. But I'm looking to the committee to see what else anyone has to add. Councilor Williams?
I'm glad that Councilor Remy brought this up, and some things I like, some things I have concerns about. You know, an example of a Class 6 road, which, you know, I would like to lift some of the restrictions on would be Beaver Street, which is an urban area. And Upper Beaver Street is considered a Class 6 road because it was so steep. Someone was telling me about the history of that particular spot, and apparently it used to be Keene's Toboggan Run. So that's how steep it is. But it's a Class 6 road, and recently, you know, we had someone come before us wanting to build a driveway there, and I think, you know, we could do better by the neighbors of Beaver Street if we took better care of that particular stretch of road, and maybe this would help with that. On the other hand, you know, I look at Old Gilsum Road, which is it goes through, you know, some of our most pristine wildlife areas here in Keene. There are some private lots up there, but it's mostly publicly owned. But I would hate to see a situation where, you know, someone was able to build a massive McMansion up there or something, because of this rescission. So I would like to do this in a way that protects Old Gilsum Road, and maybe there's some similar roads around in the rural area that would need similar protection. Although as far as Class 6 roads in urban areas or residential areas, I think this is probably a good thing to do. So it might be worthwhile, and you know, also considering that we've got the master plan happening right now, it would be maybe useful to get some feedback on, you know, where the master plan is going in that direction. But I would like to do this in a way that continues to protect the land around Old Gilsum Road.
So, and City Attorney, correct me if I'm wrong, and I'm trying to pull up a map of Old Gilsum Road right now, but my internet is not participating. That the state policy or the state RSA requires that the council review every permit request regardless of what policy we have on file. So there would not be a permit request for a building permit on a Class 6 road that wouldn't come before council.
Well, I'm going to tune that up a
Okay.
little bit. Sorry about that. 67441 is a fairly lengthy statute. It is a bit complicated. I've been scratching my head a little bit since the last time we talked about this, and didn't have the opportunity, and the clerk's office has been a little bit short-staffed, but I wanted to sort of pull the legislative history on it a little bit. There is a sentence in the statute, fairly far down in it, that says this section shall supersede any less stringent local ordinance on file. So that says to me that you do have some latitude, back to Councilor Williams's point, which I would like to think about more. But that doesn't change the question about rescinding the existing ordinance, because the existing ordinance mostly talks about driveways, which is already in our land use code. And it has a strict prohibition on any building on a Class 6 road. And I think that that's not where the council's intent is at this point, especially after the last conversation that we had with respect to the property on Beaver Street. A strict prohibition could be sustainable under the statute. There's no case law on it. I have some particular concerns with that language with respect to the possibility of a taking. So I'm not going to tell you that that language allows us to supersede anything, but it was of interest to me that it's in there. So what all of that says to me is I think you have some latitude in what you may want to do with respect to building on a Class 6 or a private road, which is quite frankly why the second motion that is before you is to have the city manager through, you know, the city staff, upstairs, fourth floor, put together some possible criteria for looking at when you would consider issuing a building permit on a Class 6 road. So I think that there's more latitude than I may have led you to believe, and I apologize for that.
So I don't think that you misled me that there wasn't latitude. I think that I was just indicating that RSA requires that we review each request.
I think that's right. But I also think that you can review each request, and if it doesn't fall into the criteria that you may have established for this,
Correct.
you can say no.
Right. I'm just saying that if we do not have a set criteria, we would still be the criteria.
Yes, exactly.
By the matter of fact that it has to be reviewed by the council and by our board in general. So it's not gonna pass any particular standard if it doesn't pass our approval.
Right, exactly. The bottom line in all of this is, although there is an appeal provision in it, just to
Right.
keep in mind, but the bottom line in all of this is, the city council should review, under the statute, each one of these applications, consider them on their own merits, and make a decision. And maybe you have some criteria that guide you in doing that.
Yes, that's right. So I'm personally comfortable with the rescission of this particular policy because I don't think it's serving us right now. And then asking staff to move forward to, in their laundry list of things we keep asking for, to put this on the, on their more time. Would this need to go to joint committee?
No, this would not be
It would be
a
another
change to the
council
zoning
policy.
ordinance.
Okay,
At that point. I'm not going to suggest, because as you know, that the joint committee does deal with questions sometimes that are not strictly zoning ordinance related. So I think it's certainly up to you and the council as to how you want to procedurally handle it at this
okay,
point.
great. That's good enough for me. All right, does anyone, Counselor Jones, have questions?
Thank you. Well, it sounded like we were given a choice of rescission or
Councilor Remy's letter suggested a modification
modification
or
or
rescission, but
rescission, yeah. Would rescission just give us the same wording as the RSA?
yes,
Yes.
you would default back to the statute at that point.
So modifying wouldn't do anything for us.
And the problem with modifying is most of the language in the resolution, as I pointed out, is already codified in the land use code for driveway standards. So that would be sort of ineffective, even to modify that. And then the second part of the resolution is basically, thou shalt not build. So that's where you're now considering, if you rescind it, you just default back to the statute. We get another application, and keep in mind, in the 16 years that I've been doing this now, I think we've had two. And both of them recently.
Yeah.
So, but you would default back to the statute, and just consider them as they come in.
Sounds good.
Counselor Haas?
Yeah, thank you, Madam Chair. It's interesting that when this first came up, it was kind of a surprise to everybody, and people had to go digging to find it. As in my reading of it, and my uneducated reading of it, it sounds like something that was passed in 2000 to accommodate a very unique situation. And I think we are well served to move away from such things. And let's get this out of here. Thank you.
All right. Anyone from the public wishing to speak? Welcome. Please state your name and address for the minute taker.
Yeah, good evening. Jared Goodell, 39 Central Square, Keene. So I recently was impacted by this statute, maybe not so much the resolution, and I was hoping that that maybe this board or the council would be willing to take a broader look, specifically at the statute, and take a preemptive action on that. So, in addition to Class 6 roads, as I read it, and what I believe impacted me on a recent project is that the city council also has to approve the building on private roads. And a private road, as I read it, the definition could be, if two houses share the same driveway, essentially that is now a private road. And that's just my understanding of it. I'm not sure if that's correct. So in it says, in the statute, it says that if it's a private road, that the local governing body, after review and comment by the planning board, has to vote to authorize the issuance of a building permit for the erection of a building. And so this is separate from the Class 6 road issue, and I guess I understand and agree to an extent with the comments of Councilor Williams that specifically for Class 6 road construction, each permit should come to the board. But I wonder if not, as the city attorney just mentioned, that these requests are coming up now largely because of infill development. And I think that's what the city really needs is infill development, and that's where we're going to see development. And so I think you're going to run into a lot more of these cases, specifically on private roads, probably more so than Class 6 highways. And so I wonder if the city staff could put together a list of private roads that exist today, and the planning board could review that list and say, we're comfortable preemptively with building permits being issued on these private roads. And I don't think that the statute says that a building permit has to be pending for you to review those streets. But from the developer standpoint, it would certainly take, 45, maybe 60 days out of the process of obtaining a building permit. And it could certainly help to jumpstart infill development if, a property owner sees that, they're just kind of given the poke that, oh, I could develop on, this piece of land that my private road has access to. So I would just maybe suggest that the board and the council maybe look at preemptively identifying private roads that it would be okay with building occurring on.
Okay, that's an interesting take on it. Yeah, sure, Counselor Jones.
Jared, is this a time-sensitive issue for you?
So I had to come to the board. I already came to the board and
Yeah,
got
I
approval.
know that. I didn't know if there was something else coming up.
I not currently, but I mean, it certainly could happen. And I think that just, I think for efficiency of the council too, do you really want these things coming up every time, or if you could preemptively identify them? And I think I just perused through Access GIS before I came in here, and a lot of private roads are already listed. So, I'm assuming that in the city's database, if you will, these, there's to some extent a list that would be easily identifiable. And I think this would really help development and actually could jumpstart development.
Okay, and just so you're aware, on the agenda for the joint committee, private roads is coming up on the more time.
I wasn't aware of that, but thank you.
Oh.
Yes,
You know
so
everything, okay.
we, I think
Good man.
that we need to take a look at the further development of private roads by developers in general. I think that currently that's restricted, and we're interested in maybe alleviating some of those restrictions, or at least having that conversation.
Sure. Anytime we can go to less boards, zoning boards, that certainly helps just the process move along, because it can be tiresome and cumbersome, and so.
Yes, and I do understand from the perspective of somebody who's had to do this, it's really good to hear that. I think it's hard for us because we get caught up, we're in the forest, and it's hard to see the trees sometimes.
Sure.
And does City Attorney, do you see a problem with that as a concept?
Well, no, and I appreciate Mr. Goodell's tune-up. We've been focusing here on Class 6 roads only because it came up in that sort of context recently. But private roads are included within the statute. The problem with this ordinance, and the reason why we didn't necessarily strictly, the resolution, we didn't have to suspend it before, is this resolution was drafted before the statute was amended to incorporate private roads. So I appreciate the tune-up. What we're going to be talking about is not strictly Class 6 roads in this context. It will be inclusive of private roads.
Do you see an issue with the way the statute is written, that we could preemptively authorize permits on specific
I think you
roads
could do
without
that.
permits pending?
I think you could do that.
Okay.
Because of the statutory language, it talks about the issuance of building permits on a Class 6 road or portions thereof. So I think that would be part of the criteria that you would want to do. And I think the suggestion to take a look at at least what we know of as private roads in the city. My understanding is that, over the last, especially since the tenure of our recently retired Public Works Director, we have had an effort not to have private roads in the city.
Right.
But I think that would be beneficial to know that. And it would also be beneficial to preemptively start looking at the Class 6 roads, according to, Councilor Williams's comment about where you might be considering, yes, this is a possibility, but nope, not here.
Right.
I think you could do that.
Okay.
That will require work.
Yes.
But in the meantime, as I said earlier, rescinding this resolution just puts you right back into the statute at
Yep.
that point, and you can consider them on their own merits
Yep.
until such time as you develop a broader policy.
Yep. Great. Anyone else have any comments? Councilor Williams?
Yeah, just to say, Mr. Goodell's suggestion, I think, is a good one, and maybe that can be part of the creation of criteria for Class 6 roads. Just look at them all, and propose some good policy to us is what I
Yes.
would ask for.
Great. All right.
Just to close out on that conversation a little bit, I mean, the statute is very clear that even if you allow this to happen, right, the city can't assume any liability with respect to this.
Correct.
And that includes the access of emergency vehicles to these properties. There is a sort of an assumption of the risk built into this process. And part of your criteria really should include the public health safety requirements associated with where somebody wants to build something.
I would just add on to that. I've seen over the years where, individuals will build in a private road and maybe not be as accessible to a fire truck. And then there to be concerns from the people who are living there. And so one of the things we really do need to take into account is fire access to these homes if they are in fact built on private roads.
All right, well, I think it brings me back to, I think we're all set with you, thank you. I think that brings us back to the original question here, and that is, are we interested in the rescission? And I think at this point, I would be open for a motion. Councilor Williams, if you're okay with that?
Okay. Move to recommend the rescission of Resolution R 2028.
Second.
I have a motion by Councilor Williams, seconded by Councilor Jones. We'll take these motions separately, I'm guessing. Is that how you'd like to see that, City Attorney? All right, do we have any questions on that? Seeing none, I would ask for a vote. All in favor? And that is unanimous. And do you want to follow up with the second motion?
Move to recommend that the city manager submit proposed criteria for the city council to consider when determining whether or not to authorize the issuance of a building permit on a Class 6 road or a private street.
Second.
Motion by Councilor Williams, seconded by Councilor Jones. Any questions on that motion? Seeing none, I would ask for a vote. All in favor? And that one is unanimous as well. All right, we will take those to full council next week and see what the council decides. The last thing is our Rules of Order Amendment Number 4, Section 25, Communications, and the city attorney is going to get us started.
Sure. Thank you, and you'll see also present all the way in the back of the room is the city clerk in connection with this. Being also deeply involved in the rules and being able to use the rules. Anyway, there was a fair amount of discussion previously about this particular language in the amendment, and just to remind everybody, it really does focus on the last sentence in the proposed amendment, and for the public's sake, I'll read it. Communications requesting that the city council consider matters not germane to either the state or to the city, over which the city council lacks the authority to take any action, shall not be agendized by the city clerk, provided, however, that the city clerk shall place such communications into the councilors' mailboxes. As you know, at the last city council meeting, there was a fair amount of discussion with respect to that, and whether that language is appropriate, whether there was a different approach that could be taken. And it was referred back to PLD for purposes of this discussion. And what I think I'm going to tell you right out of the gate, and it's unfortunate that this committee hearing is being recorded, because I have to say that I think Councilor Filio was right. Strike that from the record. That there is an easier approach to this, quite frankly, and really, it's one where right now, a communication comes into the city council, the mayor and the city council, goes into the city clerk, and, unless it's something that can sort of be easily disposed of through a city staff or otherwise, and may be referred back to the city manager for action, or if it's something that, is a personal attack, defamatory, doesn't get on the agenda, it gets placed on the agenda. And in this kind of context, communications such as the ones that we've been receiving recently could be placed on the agenda by the city clerk. That takes her out of this picture, which I'm sure that she would appreciate. And it goes onto the agenda. The mayor then, and still has the authority to look at the communication that's on the agenda and say to the city council, I don't think that this particular communication is germane to what the city does, and unless there's objection, I'm going to accept it as informational. At that point, there can be, as there was in the past, an objection to the ruling of the chair. That only requires a majority vote to overcome. And if that, the majority of the city council decides that they don't want to just accept this as informational, but to act on the matter, they can do that. They can refer to a committee for further conversation. That already all exists in the rules at this point.
So what I would say, and I'm going to steal your words, but to tune that up a little
Yep,
bit, is I think that the one piece that's not being addressed in what I'm hearing you say is that there was some desire by the council to have a public understanding of what the council was willing to hear and what the criteria would be for that to maybe get amended. So after that meeting, I thought about this a lot as well and came to the realization that a challenge of the chair is a simple majority, and so that's an easy way to get back to what Councilor Madison and Councilor Williams were looking to do in our first review of this, which is lower that bar from a 2/3 majority, which would be a suspension, to get to something that's more practical for a counselor to be able to do. Would it be responsible to include language in this that says something like, the city clerk shall place items that are not germane on the agenda and the chair will accept those as informational? And that gives the public a path of what the expectation is, and then the council understands that their ability to challenge that decision is a simple majority.
The answer to that question is yes.
Okay.
I think you could do that. I guess it sort of begs the question a little bit, and the city clerk again is here and can speak to this. It sort of begs the question again about who makes the determination that something is germane or not germane. That still leaves that with the city clerk to make that decision, based upon what I think I heard you say.
Well, it would be the committee that the chair would meets. My understanding is that we have a policy, I think it's the following policy 26, that, or rule that says that the clerk meets with the city manager
Yes.
and the mayor.
Yes.
And reviews every communication, and I believe by default, she includes the city attorney, if I remember correctly in our discussion.
That is correct.
Yes, that's true.
So that, it would not be one individual
I agree
making
with
that
that.
decision, and it would be the mayor's final decision on the floor when he reads the communication out to say, this is being accepted as informational.
I agree with that. That is true, that it does go through that process. And I appreciate your tune-up on that, because that's right.
It goes both ways.
It does.
So I mean, I feel like the council can have its way with some language, but I would like to see that spelled out in there. I think that what not having anything written kind of leaves us open to the back and forth, the he said, she said, this is what you did at this point, this is what you did at that point, why did you make this decision then, and you're not making that decision for me? And it makes it very transparent at what the expectation is and what the bar is. And so, if Counselor Williams' challenge had been seconded and there were 7 other counselors that were in support of that, that's a very clear path to move something back onto a committee's agenda. And it shows that there are a majority of the council that's interested in talking about it. I think that I've given this a lot of consideration, and at the end of the day, I want to hear things that our community wants us to hear. I want to, if there's a group of Keene residents that are interested in our time being spent on a specific item, I think that it's appropriate for us to be spending our time on that item. But what I don't want is a bunch of special interest groups trying to use our room as a platform for their personal agendas and not for the community's agenda. And I just want to make sure that we create some sort of boundary. Counselor Jones first, and then Counselor Haas.
Yeah, can I just going from memory on some of the issues we have discussed at council. Of course, we're all familiar with the Palestinian one, which was what started this conversation. We did one once supporting Ukraine, and I voted for it, but you know what? We should probably not have done that.
We did not.
Oh, we did, there you go.
It came up and we decided not to consider it.
Okay, there was one Medicaid for all.
We did.
And they went out on a long chain to try and link it to the city by saying it affects our employees.
Yes.
Would you call that germane or not germane?
I would have called it not germane, but they did make a connection, and the council decided that it was relevant.
Okay, and the other one was, it was on the Paris Climate Agreement, and I think that was germane because we have a climate action plan in Keene. So yes or no, I'm thinking that is germane.
I mean, it's hard for me. I wasn't here when that came in, so I don't have any knowledge of what was written in that communication and how they made the tie, to the community.
But I think we did it just because because we had a plan in place and it affected our plan. So I'm just trying to look at how we're going to determine what's germane and what's not.
Well, I mean, I think that what's being proposed creates a fail-safe method for you, because you'll still be determining that, because you'll see the communication, it'll come in. If it's something you think is germane, you can challenge the chair, and if there's enough counselors to do that, it moves forward. And so I do think this provides a way to make sure that it's not just the 3 or 4 of us making this decision, that it's very transparent.
Right. And there's nothing being placed in mailboxes and being missed or being put on someone's desk. It's agendized, and it's available for everyone to review, which I like. Counselor
So
Haas?
just as a
one
tune up
second.
on that to the city clerk, if you don't mind. So communications now are not regularly placed into the mailboxes, they're only attached to the agenda when it's publicized? Is that how that works?
That's correct.
Yeah, okay, thank you. Yep.
Counselor Haas?
Yeah, thank you, Madam Chair. So as communications come in, I've tried to work through the rules and understand the flow. Communications come in, and if they are obviously things that should be agendized, they go right to the agenda, number one. Number two, if there's any question about them being, and the words in there are routine city business, requires investigation, or requires confidentiality, they go to the team of city clerk, city manager, and the mayor?
No.
All communications are forwarded to the charter officers and the mayor, every one of them.
Every one?
Every
Okay, I'm
one.
not sure that's what the rule says now, but that's what
It
we're
is the
gonna work
practice,
on.
though. Yeah.
Certainly, that's great. And then all those communications either get agendized or get put into correspondence that's distributed to the councilors, as I understand the rules.
The rules do allow what's called a direct referral to the manager for those things that could easily be dealt with in her powers. So that happens. If that does happen, the city council receives a copy of that communication with that direct referral notation on it. And then there's the obligation for the manager to report back in a reasonable amount of time to the council as to her actions.
Yeah, I think, and I'm not sure if the rules specifically say this, but as long as everything gets copied or communicated to the councilors as to what the disposition of it was, I think that plugs the hole that exists here. And maybe that's happening right now, and I've seen some coming. It doesn't seem like it's been a lot over the 8-9 months I've been here.
It
But-
is rare.
Excuse me?
It is
It is
rare.
To
So,
be sent to the city manager?
Yes, it is.
but everything else would get agendized then, right?
Yes.
So anything that comes in that I don't see in my mailbox or on my desk at council meetings has been agendized. There's nothing else leaking out. There's one point where written notification goes back to the sender, okay, if it's not to be handled, if it's not to be agendized. The sender, it'd be great if we could build into that notification that the sender should contact counsel, or counselor, or counselors in order to continue pursuing it if they so choose. I can see where somebody sends something in and gets a letter back from the city saying, no, we don't consider this germane, or you've been nasty, we didn't like how you said it, and they get frustrated at that. But if they're left out that they could contact a counselor, I think that might be helpful.
But it sounds like they're all going forward to the agenda now, if this rule
Right.
goes forward. So there never would be an opportunity for me to say your communication's not going forward on the agenda.
If this rule goes forward
That's
and
right.
everything gets agendized, then you're right. Then that takes you out of that for sure. You don't have to write those nasty letters.
Right.
So, yeah, so I may not have followed it closely. If everything's going to get agendized, that's going to be awkward, but we'll deal with it. I got one last point here. I couldn't find in the rules, and please help me, where the mayor's authorized to accept anything as informational.
I don't recall the section off the
I don't
top of
believe
my
it
head.
exists.
Yeah.
The counselor has identified another area of the rules that, as going through this, that I think we need to clarify.
Thank you.
So what section would that be in?
We would have to do that, but it'd probably be consideration of business or something like that. But I was looking for exactly that language a little bit
I
earlier.
want to say in 26 is where it says the mayor shall refer to a committee.
Right.
And that's his only option, really. But I like having the option of him taking it as informational, and then if we choose to override, we can do that.
Right. Unfortunately, Patty and I and the city manager have not had to have that, or we have not had that discussion yet, because quite frankly, what you have just identified was something I just identified recently as something that we need to correct at this point.
Could
Well-
it be in this section that you're already on, though? So that we
I
don't
don't
have to
believe
bring
it
another
says as
amendment
information. You mean
forward?
26 or 25?
25.
The section on communications.
Let's take a quick look, because I didn't see it either.
That means we have to introduce it again,
Yes, well, we would have to introduce another amendment,
right?
yeah. But I think that that's right.
Is the proper place?
I couldn't find it either.
Okay, so I think that what I need to understand is, are you comfortable creating the language
Just did.
for the 25?
What I would suggest, no,
Okay.
this is what I would suggest at this
Okay.
point. Back to Patty's point. What we just talked about is more appropriate, it seems to me, in review of items of business, which is 26.
Okay,
So what I would suggest doing is deleting the last sentence that we have proposed for section 25 on communications. Taking that out of there. So it would end after, that language would end after communications of personal defamatory or argumentative nature shall not be accepted by the city clerk, period. Now, we need to do it in three steps. The first step would be to recommend that that last sentence be deleted, motion number one,
in
in
25.
25. And motion number two, adopt rather, section 25 communications as amended, because we did change some things in section 25 to some housekeeping things. So other than that last sentence, we do want you to adopt section 25 as now amended by the removal of that sentence, right? So that would take care of section 25, because you would remove that language, and then you would need a motion to amend section 26, review of items of business.
Can we amend that here tonight?
I think that
without-
you can. I think you
the
can
council
recommend
signing?
an amendment to that at this point as part of the
What about the
process.
first reading?
I'd be
Well, then it would
uncomfortable
have
with that.
Yeah.
It seems to me the first reading would go, subject to what you believe in this, but it would go back to the city council with that proposal, and then we would submit one for a first reading.
I would prefer, I know this could sound wild and crazy,
Yeah.
but I would prefer to put this on more time
We could do that.
here and ask the council, or put in something at the council and refer them back and correct them both and send them both back together.
We can do that.
I just think it's going to be very hard for me to articulate why I want them to do A, when they don't understand B yet.
I think that's fair, and we can do that. We can place it on more time. We can place in for first reading, the proposed amendment to Rule 26,
26.
to insert what I have drafted here, and just for help, if you don't mind, just for sort of a consensus thing. This is what I would be proposing for into Rule 26, which would be at the very end of the first paragraph. Basically, communications requesting that the city council consider matters that may not be germane to either the state or to the city, or over which the city council may lack the authority to take any action, shall be agendized by the city clerk for appropriate action by the city council.
And accepted as informational.
Well, but then the mayor would have the opportunity to say, I'm
But
going
you're
to
not
suggest.
being clear to the public.
Okay.
Which is the piece that's missing.
So for acceptance by the mayor as informational,
Right.
I can do that.
I think we have, thank you.
Counselor Haas.
I think we have to get the accepted as informational item in there, because there's plenty of other things that are not exciting, like international events and such, that we can dispense with easily by accepting that. And there are informational things that come up. So I look forward to getting that wording in.
We can,
And I-
when we do the first reading for this, for 26,
Yes,
we will include that.
thank
And I
you.
love the idea of putting on more time to hash this
25,
out.
yes,
So, all right, so that's essentially what it'll look like.
thank you. Counselor Jones?
Thank you. I agree with the chair with the more time, but I would just ask that the background notes show our intentions are to take that last sentence out of 25 and amend 26.
Sure.
Yes.
In the background notes.
Counselor Williams?
I'm glad this will be on more time, because I just need some time to think about it. I'm not particularly comfortable having the, I like Counselor Bosley's idea of making it clear to the public, and I think that's important. But I don't think saying, and it will be accepted as informational, that's a directive to the mayor, which I'm not sure is appropriate for what we're doing here. I think the mayor may want to not accept it as informational for various reasons.
I don't disagree.
But I just want to think about it a bit more.
Well, I think getting something into council for 26 for people to read and come back to us with suggestions on, and putting this on more time is the right path for now.
I don't disagree with that. And back to Counselor Williams's point, I think that's why I said appropriate action
Right.
in considering this now, because once it's in the rule as a directive to the mayor, then thou shalt accept it as informational. And
think
I have
that-
an issue with that.
That I need you to, over the course of the next week, think on
Yes,
this,
right.
because the intention of the council, what I have heard from many counselors, is that they want there to be some sort of obvious place that the public can go to that understands what the intention of the council is.
Yes.
And that there's then a mechanism for the council to undo that when appropriate.
Right.
And I think that's what we need. We need that language proposed to us.
So part of it, and just thinking again, right off the top of the head, would be, agendized by the city clerk for consideration by the city council as to whether or not to accept the communication as informational, something like
Something like
that.
that. Fine,
Something like that.
but we need to have it.
Yes, I get that.
Some direction.
But the counselor has identified what was nagging at the back of my
Yeah.
brain when we talked about this first language, which is, gee, that's sort of directive to the mayor, and, is that a violation of the rule that you have to suspend?
Right.
So, okay.
Okay. Counselor Haas.
Thank you, Madam Chair. Just to reiterate and reinforce, conclusion here is that we do have a good process that works. We just have to tighten up the front end a little bit. That got identified by a hot button recently, and we're going to be in a much better place when we have this tightened up, building on our existing rules.
Yes.
Thank you.
All right, anyone from the public wishing to speak?
2 for 1. Jared Goodell, 39 Central Square. So I just first want to say that I really appreciate that the council, seemingly as a whole, is very much in favor of letting people's communications, no matter how ridiculous they might be, at least see the light of day, even if just for a moment. I had a communication earlier this year that the mayor referred as informational or accepted as informational, and it was challenged. It ended up going through the committee process and was handled that way. And so I agree that the system as it is now works. I think, however, there is a different approach to this issue, and this is something that's bugged me since Pumpkin Festival back in 2013 or 14. And that is, and it just came up again in the Palestinian issue. What jumped out at me in the news story was the headline was Swansea woman was arrested at Keene City Council meeting. And I have nothing against Swansea women, except that this body represents Keene, and it represents the people of Keene. And whenever there is a hot button issue, and I go back to Pumpkin Fest, Keene, the city council is, becomes the forum for people from Vermont or Maine or other cities and towns in New Hampshire. And in a lot of ways that waters down or affects your decision-making based on people who are not your constituents, and it's not representative of the people of Keene when other people are commenting on issues here. And so I know it is an interesting take, but I think that, I think it would be nice that unless a person has a nexus to Keene, either owns property here, resides here, or owns a business here, that their communications, unless sponsored by a city councilor, are not heard, or that their testimony is not heard, unless, of course, they're sponsored by a councilor who might see their opinion as relevant. But I think that it's always just bothered me that we consider the opinion of people outside our community, especially on major issues. And I don't know if it's legal or not, but I just wonder if it might be possible to restrict communications to residents or people who have a nexus to Keene.
Great,
That's
thank you for your comments. I do know that during COVID, this was particularly like a giant magnifying glass was shown on this problem, because people across the country had access to different councils, and we were seeing groups from North Carolina and Florida coming to speak about things that showed up on our agenda. And I think that's when at my first realization of how this could be abused. Originally, I did not see that having something agendized was an issue, but I feel like that was my first moment of, oh, okay, these are not people who are interested really in Keene's opinion. They were interested in some sort of publicity story. And I think that's what I really want to avoid, is being used in that way. I do think that there are some things that are important for us to discuss, and sometimes those things are bigger than Keene, but most of the time are probably germane to the state of New Hampshire. And I think that what you're saying is sponsored by a counselor, but what I hear is by a counselor challenging the chair's decision. That is, in fact, a sponsorship by that counselor of that article. That is our ability to stand up for a piece of a communication that is important to us. And really, the 15 people in this room are the people that the public reach out to, and that the people from the different wards and streets contact us, and they use us to speak their opinions in this forum. And it's a really important role. And I think that in general, most of us kind of know what the community is interested in. And there might be different counselors who have different access to different groups of people, and that's important. So, if Councilor Williams is saying that there's a certain group of people that are local to Keene that he wants to represent, I think it's important that he has an opportunity to plead his case in front of the council. So I do like that that there are things that will be agendized, and I think that the 15 of us need to be very cognizant of whose communications we're supporting and for what reasons. But with that being said, I do want to get some motions on the table tonight. Counselor Jones, are you comfortable?
Well, it's easy, right? Because everything's in the
Madam
background
Chair,
notes. We're just,
if you don't mind, I think it's important to speak to Mr. Goodell's comments.
Okay.
I think it would be no surprise to the city council, and while I respect his position, that I would have serious concerns under the First Amendment.
Right.
With respect to a proposal like that.
To limiting out of
Yes,
town, yes.
and including just the practical realities of, that would be associated with it. But that would not be something that I would be recommending
Yeah.
to the council.
But we do have the opportunity for people to state their name and address, so we are aware of who's speaking.
But remembering as well that individuals are not required under RSA 91A to do that.
To do that. We just ask.
And most people accommodate us.
Good to know.
can I ask a question?
Counselor Jones, yes.
I'm thinking now, this brought up another thing. Years and years ago, there was a motion before us to add fluoride to our water. Long before you were here, Tom. Patty probably remembers it. And we were getting letters from people in Florida and stuff like that saying you should use fluorine in your water. Is that something the mayor can use as his criteria for being germane or non-germane?
No.
I think I missed that entirely. I'm sorry about that, You mean because fluoridation is not a city?
Because somebody from Florida no, it was a city issue,
Yes.
but somebody from Florida was,
Well, Jermaine is relating to, not relating from.
Can I clarify?
Yes, Counselor
Thing,
Haas.
I think what Counselor Jones means is that verbal communications, we would not restrict for First Amendment rights, but written communications, can we restrict them?
No, written communications are subject to the First Amendment like every other communication. First Amendment does.
Yeah, you're right.
Actions can be First Amendment protected. The wearing of a patch on your arm can be First Amendment protected.
but
It's
And I'm-
a very slippery concept.
I'm thinking of the mayor because he's the elected and our charter members aren't, so he's kind of part of that determination. Can he look at that criteria?
No, he's still a public official. Remember, the First Amendment constrains, and this is so misunderstood in the world. The Constitution of the United States constrains governmental action. He's an actor of the government in his capacity as the mayor. You all are, when you are acting in your official capacities, subject to the First Amendment. Private entities, generally, except for for commercial speech, are not. So there's a misunderstanding about that. But no, he's still a governmental actor. He would still be subject to the requirements.
Thank you.
And we do agendize letters there's a gentleman from California who writes to us very regularly about the downtown project, and those items are agendized, and we review them. So I think there's, lots of instances where that happens.
I don't disagree with this, and I have to share with you that when I heard you, Counselor, talking about fluoride, all I could think of was the movie Dr. Strangelove. So I sort of blipped out for a minute on what you were saying.
It was just an issue that we had to deal with a long time ago. And as far as the motion, everything's in the background notes, it's to put on more time,
More
correct?
time, please.
Are you ready?
I'm ready. Yes.
I would move to put, I would move to put Rules of Order Amendment Number 4, Section 25 on more time.
Second.
Motion by Counselor Jones, seconded by Counselor Haas. I don't see any questions. All in favor? And that one is unanimous. So we'll be looking for some wonderful crafting that you're gonna come up with.
Absolutely.
And then we'll couple them together and bring them back as a package. All right, we got to the end, and we did it in just about an hour, so I really appreciate everyone's time tonight. Thank you all. This meeting is adjourned.